True or false, estate planning is just for the wealthy? Stay tuned as we explore this statement on this edition of Headlines in Fine Print. Hello, and welcome to Headlines in Fine Print with Dion Williams, brought to you by Piedmont Advantage Credit Union. I'm Dion Williams, President and CEO of Piedmont Advantage Credit Union. On today's episode, we're going to debunk the myth that estate planning is just for the rich. Furthermore, estate planning is so much more than just having a last will and testament. There are other documents and tools at your disposal to have a sound plan in place to give you peace of mind and take the stress off of your survivors during a very difficult time. Before we begin our discussion with a look at beneficiary designations, let me be clear that estate planning is a team sport, so to speak. So some of those other team members may include a financial advisor, a tax expert, or an attorney, depending on the complexity of your situation. So let's begin with a look at beneficiary designations. So when we talk about beneficiary designations, the obvious paths point towards life insurance, 401k plans, or IRAs. Life insurance policies and retirement plans can pass assets to beneficiaries outside of your will. So our first fine print of this episode is to keep your beneficiary designations current. So things happen in life, right? Sometimes there's divorce, there's remarriage, there's folks that may be your beneficiary that's designated who passes away. So it's very important that as those life changes happen, that you make sure those designations are set up in a way that assets pass according to your wishes. Because remember that your intentions are not what determine how those assets pass. It's actually what's on that piece of paper that you signed. So keeping those up to date is crucial. Don't lose sight of keeping the intentions and the designations in alignment with one another, because life changes can and will occur. Did you know that other accounts can have beneficiary designations too? So whether it's called a beneficiary or a payable on death beneficiary, you can designate regular deposit accounts such as checking, savings, money market, and certificates to pass to a beneficiary upon your death. So how is this useful? In the absence of such a designation, assets will go to your estate, and the probate process can tie up assets and create headaches and time delays that could have been avoided if the beneficiary designations had been otherwise deployed to bypass the probate process. So in taking a step back, when someone dies, the grief and emotions are enough on their own without the complications of navigating the estate of the deceased. Beneficiary designations are an excellent tool to ensure your wishes are carried out and alleviate stress on your survivors. Okay, the next section is don't forget about the kids. And if you recall from our previous episode, we had, on that episode was on credit freezes, and we had a section on don't forget about the kids in that one as well. So it applies here too. So that's another fine print. You could be broke, have zero assets to your name, but a will is still important as it applies to minor children. So in the unthinkable situation in which both parents are deceased, who will have custody of your kids? The courts will have a lot to say about that if you do not make your wishes known by way of your will. So although it goes without saying, I'll say it anyway. Be sure to have a conversation with the person or persons that you're going to entrust the care and guardianship of your kids to in the event that you're no longer here. So make sure that they are aware of the circumstances in which they would take the guardianship and that they are up for it, because it's a huge responsibility, and communicating that is absolutely critical. Now, when we talked about beneficiary designations, that was geared towards financial assets, but now we're talking about your kids, and your kids are priceless. So when we say estate planning is not just for the rich, this is really the best example. Whether you have financial assets or not, the will can clearly communicate your wishes for minor children in the event of your death. Now, the next section, we get a little bit more down the legal path, and that's on healthcare directives. So we're going to talk about 3 healthcare directives and then another directive that it's a legal document, but not necessarily pertaining to healthcare. So we talked about the importance of communicating your wishes regarding your minor children, but now we're going to shift the conversation to the wishes for yourself. So I'd like to talk about the 4 documents here: living will, healthcare power of attorney, do not resuscitate orders, and a financial power of attorney. Now, I will tell you right now, I'm not an attorney. I don't play one on television. But when we get into the estate planning as a team sport concept, here's where an attorney can really add value to the process for you. And with these tools, and having a basic will set up, as well as these documents that we're going to discuss, it's not the most expensive endeavor. You're not talking about thousands of dollars in most cases. It's usually just a few $100s, and the investment is well worth it for your time and your peace of mind. So let's start with the living will. A living will essentially conveys your wishes for medical care in the event you're unable to communicate them for yourself. So one example of this would be if you would want to be kept alive by artificial means. And once again, keep in mind it's an emotional time for your family members, so having to speak for yourself makes a difficult time less stressful as your wishes are clearly known. Next, healthcare power of attorney. In the event you're unable to make decisions for yourself regarding your health care, this document designates someone to do it for you. It's important for you to have a conversation with the person designated so he or she understands your wishes, so they're aware of the designation as well as what your wishes would be if you were unable to make those decisions for yourself and they were having to make them on your behalf. The third one is the do not resuscitate order, and that simply states that you do not want to be resuscitated if your heart stops beating. And then last but not least is the financial power of attorney. While this last one is not a healthcare directive, it's included here because it's also a legal document. But a financial power of attorney designates someone to handle your financial affairs on your behalf. Now, the POA or power of attorney can be structured in different ways, and this is an example of the value an attorney brings to the situation again, because a POA without parameters could allow a bad actor to take advantage of you. In many cases, the power of attorney regarding financial matters is triggered by an event and may even require a doctor or doctors to sign off on your fitness to handle financial matters or lack thereof before the power of attorney allows the designated party to act on your behalf. So this tool is very useful, but again, communication with your designee and an attorney must take place to make sure the correct document contents and triggers are in place to protect you and your wishes. Now, regarding the healthcare directives and legal documents, be sure any medical-related documents are on file with your healthcare providers. Documents pertaining to your finances should be shared with your financial institution. Anyone designated to act on your behalf should also be aware of the documents and how to activate them. So when you meet with an attorney to have those documents drafted, they can provide further instruction on the filing and storage of those documents so they are ready when needed. So just take a step back for a moment and think about, what if you had these documents drafted and you put them in a safe deposit box? And that's where the only copies existed. If something happened to you, no one would be able to get in there to know that they exist or what those contents say. Or if you put them in a safe in your home. So it's really important that you have those documents stored with a trusted person, that the attorney has a copy, your doctors and healthcare providers has a copy, your financial institution has a copy for anything pertaining to financial matters, and that way it's out there, so if something happens, you're not scrambling to come up with the documents. You have everything in place so the plan can take action according to your intentions. So my closing thoughts, we hope you enjoyed today's episode, and I hope also that I was able to illustrate why estate planning is not just for the rich. So for that initial question today, it's false. Estate planning is not just for the wealthy. It's not just for the rich. It really is for everybody. There's so much more to it than accumulated wealth. As always, your credit union is to help if you have further questions as this topic applies to your individual situation. Thank you so much for joining us today for Headlines in Fine Print with Dion Williams, brought to you by Piedmont Advantage Credit Union. We'll launch a new episode each month and discuss topics that are relevant to your financial life. We have a wealth of resources on staff that can provide information on a variety of financial topics, and we look forward to sharing those with you. And in relation to today's episode, we have financial advisors on staff that can get you started down that process of estate planning and be part of that team that helps you get your wishes put into place. If you'd like to learn more about the credit union or how to become a member, please join us at pacu.com, pacu.com. And as always, please don't hesitate to reach out if you have questions regarding today's episode or to suggest topics for a future episode. You can reach me at Dion, Dion.Williams at pacu.com. That's Dion.Williams at pacu.com. Or my number is 336-750-7088. 336-750-7088. Thank you again for listening and hope you have a great day.